All right, that's working. I can handle that technologically. So thankfully I didn't present slides, and thankfully I am here in person. So I think I can get through this. Just a couple of comments. Norman had the slides. He indicated that the Supreme Court in the United States has had a difficult time with Section 101 and the utility standard in the United States. And I think I agree with that. For me, I wish 101 was kind of a gating function for U.S. patent law. And if you recite a specific and credible utility, you're in, and then you start getting to the substantive requirements. Was your patent application well written? Does it fulfill the requirements of Section 112 that requires you to describe the invention in precise terms, to claim it in precise terms, to provide an enabling disclosure so that somebody picking up your patent and having ordinary skill in the art can practice the invention. And I think as Virtue said, there's this kind of give and take in exchange for the exclusive rights that the patent provides you. You have to give something to the patent, the public, not the patent. And then, after a limited duration of time, the public gets to use that technology freely. And so, the U.S. is struggling with a lot of policy issues. They tend to end up in Section 101. And for a patent attorney that's trying to protect inventions, it's not kind of a good thing. It's not really well settled feeling for me to try to navigate that. Richard was indicating, in Canada, there's this, when you get to secondary use patents and you're talking about later inventions, oftentimes that you need to demonstrate that the later invention was patentable over your earlier work that's in your earlier patents. And so, there are doctrines in most countries in the world where you can establish that for some reason, there's unexpected properties, there's much better results. In the United States, we have things like long felt need, where you can demonstrate that you're satisfying something from a need that the public had wanted for many, many years. There's commercial success. I think the difference between kind of this doctrine in Canada and what we have in the United States is, at least we don't need to put that into the patent application in the United States at the time of filing. As long as we're claiming the narrower invention or the follow-up invention, we can come in later on with evidence that was either generated before the filing of the application or maybe it was generated afterwards to show that this particular invention meets the requirements of the patent statute. And we tend to look at that issue under the obviousness section of U.S. law, not 101, thank God. There's a novelty section, Section 102, which with good drafting and a good invention is typically fairly straightforward to show. And then a lot of the activity in the United States surrounds whether something is obvious or non-obvious. And the Supreme Court addressed that a few years ago in KSR because I think as a matter of policy, the Supreme Court and many people in the U.S. public felt that people were getting inventions too easily. And so one of the fixes there was to tighten up the obviousness standard and what is the reason that somebody would have changed the technology that was described in earlier publications and patents to arrive at this new invention. And so, when you go through examination in the United States Patent Office, many times with respect to obviousness, you get the rejection from the Patent Office, and as a patent applicant, you have the opportunity to address that and to demonstrate that there's something that works particularly well about your invention that kind of so that you kind of meet this non-obviousness standard and you're entitled to the second invention. I think in the United States, our utility standard, there is kind of a credible utility standard. That there has to be an assertion in the patent application of some sort of recognized utility. For a long, long time, the medical arts, both compositions of matter and methods of treatment, have been considered to be kind of industrially applicable or part of the arts. And so a method of treatment has been treated as falling under the process section of 101. This is different from other countries. Europe does not allow methods of medical treatment, either veterinary or human treatment. There are ways of getting protection for those types of inventions, but it tends to be use claims or secondary use claims. A lot of times the language that you're using is kind of the steps that go into manufacturing your medicament, and it kind of has an intended use type of limitation in the claim. So that it differs from the United States. You can't get a method of treatment claim in Europe, but kind of the concept of getting some sort of protection for these later medical uses does exist in Europe. The credible utility standard in the United States is sometimes we fight that kind of battle under Section 101 as a utility type of rejection at the Patent Office. Other times it kind of falls under Section 112, which is the how to use the invention. If it's not a useful utility, then you're not going to be able to teach how to make or use the invention. And I think starting in the late 70s, beginning of the 1980s, the Federal Circuit and its predecessor, the CPA, really kind of took a look at this, what do you actually need in your patent application if you're trying to claim a new therapeutic or a new method of treatment. And so there, you had a standard evolving. There's cases Nelson v. Bowler, N. Ray Joles, Cross v. Iyazuka, which tended to take a look at these new compositions of matter, new compounds, and say, well, how much does the patent applicant, the inventor, have to put into the patent application in order to satisfy that first hurdle, the 101 hurdle? And so it does need to be a credible utility, but the amount of data typically ended up, and the way we understand it is, so at least some in vitro evidence and testing that show that you have a particular pharmacological product. And then, the next step tends to be, is there some sort of correlation with that pharmacological activity and the use of this product later on in an actual therapy? And so, often we're filing patent applications before a clinical trial is ever done, especially the first generation and the new compounds. My clients, our firm represents innovators. We represent generic companies. We do pro bono work trying to get access for medicine. For the innovator clients that we're representing, we need to get a patent application on file at some point. And it's an art deciding when to file and how much data to get and how much to put into the patent application. But it is typically always before there's a clinical trial. In fact, a lot of our clients won't go into a clinical trial, especially more than 10 or 12 patients, where it's going to cost them tens of millions of dollars, without knowing that they have a good chance of getting a patent. And so it's kind of a chicken and egg type of situation. So I think when you go back to Nelson versus Bowler and Cross versus Iyazuka, you see a recognition by the courts of that. And so there is kind of a policy rationale for kind of that kind of placing the utility standard there. And then, I think, as patent attorneys, we're pushing the envelope in two respects. How broad we can claim. We're trying to get as much as we can for our clients. And so we have very broad claims that lead to cases like the Myriad case, where kind of the difference between what's in the claim and what's in our bodies is an isolated gene. So it's isolated. That's that's the one difference. And so, we're getting very, very close there, and we're forcing these difficult 101 patentable subject matter decisions. And then, I think the other thing is this rush to filing. How long can we hold off until we file that patent application? How much time can we wait for the generation of additional data to put into our application to support kind of the utility? And so there are situations where there's a rush to filing and the application goes in and there's a question about how much data is there. And then that typically is a scenario that leads to cases where the amount of data is questioned and there's a dispute over would somebody in that particular art find the utility of this application credible or not credible. And you see kind of the more recent cases, I know in Virtue's position paper, Rasmussen case, the Janssen case, when you look at the facts of those cases, the Janssen case had a very, very thin patent application, very little data. It made it hard to like the patent applicant or the inventor in that one because it doesn't look like there's a lot of disclosure there. The Rasmussen case was an inventorship case where you had a compound that was known in the art, and you had two companies basically racing to see if this compound that was used for treating kind of swollen prostate in men actually worked to treat prostate cancer. And so there it became kind of a race and between two companies to kind of get claims to treating cancer with that known compound. And the board at the patent office was forced to really look at the evidence very closely and decide at what point kind of that became more than a wish and became kind of the fulfillment of the idea. Last kind of points here. In the United States patent system, is set up to reward kind of innovation. It's set up to reward you for coming up with the idea in a complete form so that somebody could then take that idea and take it home to completion. It's a little bit different in places like Japan, where not only do you have to demonstrate in your patent application that you had the idea, you have to demonstrate that you actually completed the idea. And so here, it's based, we're rewarding inventors for great ideas and having them, and not necessarily for doing all of the work. If it's a situation where one of ordinary skill in the art could take your patent application and routinely walk into a lab and bring it to completion, then that's sufficient.